It's a PL matter, my lord. The villagers have filed a grievance before the collector, which is pending for eviction of the illegal encroachers from the government land and the Gochar lands. Under Annex 2,
Or the petitioner's representation bracket Annex 2 will be examined by the
তহসিলদার খৈরা
Tahsildar Khaira and after notice to petitioners and
no, collector Balasur.
no that তহসিলদার is to because these are all encroachment matters.
correct. After notice to petitioners and opposite parties 6/2/22 and giving them a hearing. The reasoned order shall be passed not later than 14th August and communicated to the parties within a week thereafter. Court clarifies it is not existed.
Item number 2.
Yes, please.
Oh, my lord, this is for the benefit of around 51 lakhs visually impaired persons in the state of
Right,
Orissa, my lord.
right.
For a specific implementation of the act also.
Right.
If I can come to the prayer right away, my lord, it is for,
So they've still not appointed a full-time state commission on disabilities. My goodness.
number one, number two.
So it's mandatory under which provision of the Persons with
Section
Disabilities Act?
74, my lord.
Section 4, is it? This is a public interest litigation brought forth by the Orissa Association for the Blind with the following prayers set out the prayer clause. Detail it is seen that under section 4,
74.
74.
I have quoted it in my petition.
Where is that?
Eighty says about the functions and 74.
Page.
That under section 66 of the Rights of Persons with Disabilities Act 2016 bracket RPWD Act bracket, there has to be the state government has to constitute a single quote state advisory board on disabilities for exercising various powers assigned to such board under the RPWD Act. It is stated that although the board was initially constituted for a period of 3 years in the state of Odisha, it has not been reconstituted over the last 3 years. And therefore, the functions of the State Commission for Persons with Disabilities
Right, section 74, my lord.
in terms of section 74 of the RPWD Act are unable to be carried out. There is also a grievance made about the woefully inadequate sum of single quotes disability pension and the failure to fill up the quota earmarked under the RPWD Act for persons with disabilities in jobs under the state government. It is also pointed out that there is no full-time state commission for disabilities as mandated under section 74
Section 70.
of the RPWD Act. So notice, Mr. Manthi accepts notice on behalf of the respondents, opposite parties, and states that a reply will be filed within 6 weeks, which are the next date. List on 2nd August.
Lord, if I can be here before your lordship in July.
No, let it be. They need time anyway to file.
My lord, if I can take the liberty of your lordship, is that there is something very small which could help which is not part of the petition,
I see.
is that to have a talking traffic light. I've written about this to the police commissioner,
Oh, I see.
especially my lords, there are 2-3 areas which are very busy.
In
very
Bhubaneswar,
big.
is it?
Yes, my lords. Next
Why
to the
don't
big
you
bazaar.
just give him a copy?
Yes.
You won't pass an order, but you can easily talk to the traffic commissioner on this.
Yes, my lord. I will discuss with council.
If that could be done as soon
Yes,
as
yes.
possible, so that you
My
will have the
lord,
benefit of your lordship seeing it before you.
My lord, may I request one thing? Your lordship is ordered that the pendency of this case will not be a bar to constitute the committee. If
Yes,
government-
yes.
That will-
It is expected that without waiting for further orders from the court,
Yes.
the state government will proceed to constitute a full-time state commission and also appoint and reconstitute the state advisory board.
Yes. Order may be communicated to the commissioner cum secretary SSCPT.
And copy of this order be communicated forthwith. The commissioner cum secretary
SSCPT.
SSEP
Opposite party number 1.
Copy number
bracket opposite party number
SSCPD.
1. Yeah, SSEPD. Yeah. All right.
Item number 3.
Item number 3, may I please your lordship, it's a PL matter, my lord, and my grievance petition is pending under annexed high file before the collector, my lord. It's a matter regarding, my lord, implementation of work under the Monrega Act, my lord.
All right. This is the petitioner's representation. No, there's already an order by the ombudsman.
Ombudsman, my lord, but ombudsman has closed the application, my lord.
Saying what?
My lord, lordship may kindly come to page 18 of the Minister 4, my lord, page 18, my lord. Last paragraph, I may be permitted to read, my lord. Though both the parties agreed not to use any machine and tractors in this project except carriage of construction materials in writing, which copy was also placed on record. As other activities is mentioned as per the norms of Monrega Act and the rules, the containment provision could not be entertained at the beginning. Hence, this case is closed for the time being, and any deviation under the Monrega Act and rules, if be reported, further will be entertained afresh and contravention of the Act provision will be imposed without assigning any reason. With this observation, this case is closed, my lord. Thereafter, I filed my grievance petition before the collector, my lord.
Actually, if any further grievance, then the same ombudsman can be
Further,
approached. But collector cannot sit over this matter because there is an ombudsman under that Monrega.
Monrega.
No, in fact, you seem to have addressed after this that Annexure 6 to the ombudsman. Just see that.
My lord, that is pending, my lord.
That's
Annexure
pending.
C, that is pending, your lordship.
Then
Conflict of decision between the ombudsman. The ombudsman is also a statutory authority.
But
So
the-
if he has any further grievance, the petitioner may approach the ombudsman.
no,
ombudsman.
which they have. See, on 17th they have.
17
Thereafter, this writ petition is filed, I think.
Correct.
18th is
We
May.
can ask the ombudsman to dispose
Yes.
it off.
No, provided she filed an application before the ombudsman.
No, that's
because-
there. Annexure 6.
Annexure 6.
Yes,
The application dated 17th April 2023, filed by the petitioners with the ombudsman.
shall be registered as a case because the judicial process is there.
MGNREGA, Zilla Parishad Jagat Singhpur, be registered as a case. And after hearing the petitioners, the ombudsman is directed to dispose of said case
Yes.
within a period of 3 months thereafter. A copy of this order be sent to the ombudsman, Jagat Singhpur, forthwith for compliance. The court clarifies it is not expressed in the matter. The petition is dismissed.
And may pay within 2 months because, my lord, the work will be complete, my lord. In the meantime, the work will be complete, my lord. There will be no.
Within 2 months. All right.
Item number 4.
But see, one is similar matter. Lots were already granted interim order. Matter regarding the minus balance.
All right. Same one. Right.
Item number 5.
Lord, 5, 6, and 7, in view of the monetary limit, can be, let's say, may disposed of. In view of monetary, limit, I don't press the
Okay. Council.
5,
please.
6, 7.
Yeah, petitioner does not press this petition in view of the revised monetary limits.
Lord, 5, 6, Lord, Mahapatra is appearing. 7, I am appearing.
Or the applications are disposed of.
Lord, so far as 8 and 9 is concerned, Lord, it's more than 3 crores and 1 crore. It may not permit me, I can file a limitation petition because the registration CMPL is filed, but without any limitation. If you also permit, then I can file.
All right. Last option to cure the defects
8 and 9.
before the next date. List on 26 June.
I'll just yes.
Item number 10.
Disposed of the symptoms.
Item 11.
May, in this case, my complaints under annex of 5 is pending before the collector. Person kind peruse page 60. It has been received.
Or petitioner's representations, oblique complaints shall be examined by the Tahsildar Sadar Cuttack. Then after notice.
Collector,
No, it's addressed to the Tahsildar, sir.
page 60, it's addressed to collector. Page 60. Person kind.
Because
It
the
has been
Tahsildar is
received.
having all the records
Yes.
pertaining to
Then
this.
your lordship may die.
All right. And after notice to the petitioner. And opposite party number 5, the reasoned order should be passed not later than 14th August and be communicated to the parties within a week thereafter.
Lordship may record the name of Mr. M.R. Mohanty, senior advocate. His appearance memo is already there, but his name has not been reflected in the
Alright.
court. And item number 12, the lordship may permitted to withdraw to file a better application.
Alright.
Yes, some latches are there.
This is disposed of is withdrawn, liberty to file a better petition.
Not obliged.
Item 13.
Just read out the name.
Item 13. Kelucharan Paikar. Deputy Sadar.
Yes, sir.
Yes, sir.
They are online. Yes, please.
Sir. First of all, I will request you, this is my third attempt to continue court. If there will be any discrepancy, the court may excuse me.
All right.
Sir, first of all, I am giving you a small discussion about this problem. Actually, this is a problem related to the public life, endogenic public life, that's what my pedestrians. And it is due to the running project, Batoga to Medical Square, road expansion. Actually, which was the project of 2015, and that was suspended due to many reasons. I don't know other exact meanings, but at that time, that was a very important project because the road was the only entry and exit to the Puri. But due to any reason, that was suspended. But in 2021, it is again restarted. And at that time, at present, there are 6 high-tech. Other than this project, there are 6 high-tech in and out segment to the Puri.
Sir, have you made any representation?
Yeah.
Where is that?
Sir, that is in annex
4. Unreadable.
to the chief engineer roads. There is a proposal proposal by the SCA current Puri. And
No, no, where is your representation? Which page?
sir, annex from sir 15, 16, 17, 18, 19.
There are only 17 pages.
Till 1920 as a
All right. The petitioner's representation. Bracket Annex 6. Regarding construction of a pedestrian footpath on the bridges over the Musa River at Garuda Square, Athranala, Puri, shall be examined by the Chief Engineer bracket roads bracket opposite party number 2. After hearing the petitioners, he shall convey a reasoned decision thereon to the petitioner not later than 14th August 2020. The court clarifies it has not expressed any with the matter. The petition is disposed of. All right.
Sir, one thing was, sir,
Yes.
the party may be directed not to proceed further. And actually,
No, you want them to construct a pedestrian footpath. So what not proceed further? Proceed further with what?
and actually, though it is in process, and they are targeting, they will come and complete this portion, our portion, before our festival. And if it will be done without footpath,
Sir, your prayer is to construct pedestrian in the pedestrian footpath on the bridge.
again,
But what you are saying that not to proceed what in respect of what?
the proceed actually, that is a problem is very critical. Because the existing bridge is not fit for 4-way. That is 4-lane.
Yes.
And
We should have come much earlier, sir. When the bridge is already being completed, you can't come in the last minute.
Yeah.
When did the construction of the bridge start?
that is in 1990, I think.
What?
1990.
Construction of the bridge.
Yeah, this is a old. These two bridges are old bridges.
Okay. What do you mean by stopping the construction then? We're not able to understand.
Then actually road expansion is there. They are planning a 4-lane roadway. And
Oh, but this is an already an old bridge.
then actually the bridge is 2-way, 2-lane, and the road is expanded to 4-way.
No, but have they started the construction or they yet to start?
Then they have already started.
When did they start? When did they start?
The land eviction was done 15 days back. They have tested everything.
So when did they start the construction?
Expanding.
I think
Expanding.
he wants to stop the construction of the road because it is.
No, it must have started because he's saying stop the construction means construction started. Somebody saying stop a construction, it means construction is going on.
That road.
No, since when is that construction going on?
From last 15 days.
15 days.
Yeah.
A road टा बंद करियो चाहूचंती.
नहीं सर एक्चुअली घटना कौन होइছে आपनकर 18 नंबर ब्रिज ता हमर गोटा छै एक्जिस्टिंग ब्रिज दैट इज 2 लेन तो ता ऊपर देखि 4 लेन रास्ता ता बर्तन आसुची माने सेना जदी आसीबो ताहला हमर से ब्रिज ऊपर हमर फुटपाथ देई हबो नाही केवल सेटा केवल
He wants the footpath to be provided for in that bridge. He says they're not providing for it.
Now they are going to construct a 4-lane.
Correct. On that he wants
that bridge is only 2 lanes. So
Ah.
he wants that 4 lanes should not be, which is not possible because it is expansion of road.
Ah,
But that bridge.
he does not want it to expand. Is it?
Yes.
No, but his prayer is there should be a pedestrian footpath.
Yes.
And that is 4-laning footpath. Perhaps he is meaning that.
No, if he wants a footpath, it's better if it expands, then there will be space for.
sir
I have no copy. I have no. He has not.
Oh, he's not served a copy.
No.
Oh.
Copy has been served.
All right. In that case, sir, you first serve a copy on the council, government council. Let him take instructions. All right.
yes, sir.
Copy of the petition be served on Mr. D.K. Monti, learned additional government advocate, in the next 3 days. Even a soft copy could be sent to him by email. Paragraph, the petitioner will also cure the remaining defects pointed out before the next date. List on. Fourth. 5th July, sir. 5th July.
Sir, actually, before 5th July, they may construct the road.
That will be a miracle, sir, if they can do it so quickly.
Sir, actually, I am praying for a portion of the bridge, road, sorry. That is
No.
from road to
It's not- Unless we know the full facts, sir, it's not possible.
Sir, okay, it's okay. I can also give them on full tax, and they also. Actually, I am praying that before giving that tax and clearing everything, they should not proceed further.
Item number 14.
Or this portion.
Let's see. All right.
Madam 14, by showing another person's house, he has taken away the money under the PMAY scheme. So we have raised an objection before the
Alright.
BDO.
All right. The petitioner's representation will be examined by the Block Development Officer, Erasma, Jagatsinghpur District. And after notice to the petitioners and opposite parties 4 and 5, a reasoned order shall be passed not later than 14th August and be communicated to the parties within a week thereafter.
Obligation. Urgent copy of your lordship.
Yes, urgent copy. Right.
Item 15.
May I please, Lordship? My lord, this is a matter regarding the construction of the Anganwadi worker, my lord. My lord, annexure 3 is the pending, the collector Puri, my lord. The
All
petitioner
right. The petitioner's representation, Annexure 3, shall be examined by the collector Puri and after notice to the petitioners and giving them a hearing. And notice the petitioners and opposite party number 6 and giving them a hearing. Opposite parties 5 and 6. Giving them a hearing. The reasoned order shall be passed not later than 14th August and be communicated to parties with the context. All right.
16.
May I please, madam? Madam, this is a public interest litigation. The present petitioner, he is from the village of Bothalla in the district of Balangir, my lord. My lord, in the village, my lord, they are newly constructing the revenue inspector office. My lord, the plot which is reserved for the Bhagavata Tungi and the villagers, they are performing their.
Annexure 4. That stamp on the left is set.
My lord, that is for to the sub-collector, but I pray direction.
Tahsildar, you've given it to the Tahsildar.
Annexure 4 to the Upazila, madam, the sub-collector.
No, it says Tahsildar, sir. That stamp on the left corner? Tahsildar. The petitioner's representation bracket Annexure 4 will be examined by the Tahsildar Patnagarh and after notice to the petitioner and giving him a hearing, reasoned order shall be passed not later than 14th August. Be communicated to the party within a week thereafter.
17.
The court clarifies it as not expressed.
My lord, this is a matter, my lord, where a new primary agriculture cooperative society has been constituted in consideration to the production of the Gram Panchayat, my lord. But that which PAX has been, they are going to establish far away from the Gram Panchayat.
Same order, this time it's Annexure 2 will be examined by the Tahsildar they've got and after notice to the petitioners.
Till then,
And opposite party number 6. The reasoned order shall be passed. Same 14th August.
till then, they should not take any.
That you can ask.
Obligation.
Item 18.
Item 18, my lord. Here the representative Mr. 4 is pending before the district education officer that regarding that to follow the norms and rules regarding qualification of appointment and promotion of teachers by the on accordance with
All
the
these
rights
are
of
service
children.
matters, sir. Gradation list and all service matter.
My lord, your lordship kindly see that the Rights of Children Free Education Act 2009, my lord. Annexure 1 is the government's central government notification.
Come to the prayer. Come to the prayer.
Yes, ma'am.
Come to the prayer.
My lord. To republish the graduation annexure 4 with the qualified teachers, my lord. OTET, those who are not passed, they have included in the list. Devotes to the rules of the central government. Annexure 1. You lordship kindly say Annexure 1. The government has fixed the qualification, central government. Unless until you pass the teachers education test, you can't be appointed, man. After 2009, but the graduation list, they enumerated all the teachers who have not passed that qualification. So representation.
All right, the petitioner's representation, bracket
4.
Annexure 4. No, 5. And shall
5,
be
ma'am.
examined by the District Education Officer Baleshwar and after notice to the petitioner given by hearing. But if your representation is allowed, many people will get out of the list. And you have to make them parties. Then you have to make them parties.
He is the authority, man. Because district
No,
education
who will
officer.
get affected? Suppose your prayer is allowed. Some person's names will get deleted, right? If your prayer is allowed,
my lord.
some person's names will get deleted.
Entire people, my lord.
Ah,
All
then
the entire gradation.
You have to
list
hear
not
all of
yet
them,
passed by
sir.
technology.
They'll all be adversely affected. You have to hear all of them.
And that way service matter,
Ah.
any other person is agreed.
All of them have to be heard. You have to first implead all of them here. Are you prepared to do all that?
That's not
No.
possible because
Take
all
the easy way.
entire
6.5 rupees, writ petition filed. In fact, you're still using an old typewriter SC. So no cost at all. Entire petition has cost you 20 rupees. With 20 rupees, the entire list of people who are in the select list will be out.
No, my lord.
Very good, very convenient, sir.
After
With no expense, 20 rupees you spend, everybody can get knocked out of the list. No hearing them, nothing. No natural justice.
my lord, the DO is to authority, he is to take to their
What happens if he starts taking you seriously? How many people will be affected?
196, my lord.
Ah. So what will happen to all of them? They'll wonder who's this lawyer, who's this High Court, not giving us even a notice.
Your lordship, call in after vacation, I will just try to make them parties or otherwise.
Try, you'll only then try. Depending on whether this client will give you anything.
My lord.
If the counsel of the petitioner seeks leave to withdraw this petition with liberty to seek other appropriate remedies as may be available to the petitioner according with law. This post office withdrawn with liberty is paid for. All right.
We need to file better application if possible.
All that you sit and decide what you want to do. Yes.
Item number 19.
May I please, Your Lordship? Your Lordship, the petitioner is a Naik Champanch of a Gram Panchayat and OP number 5 to 14 are the enclosures, my lord. My lord, Annexo 1 series are the representations made by the petitioner to the
All right.
authorities,
The
my lord.
petitioner's representations.
My lord, may direct the
Bracket Annexo
Tahsildar
1
to take a
series shall be
decision, my lord.
examined
By the Tahsildar.
by the Tahsildar Bir Maharajpur, District Suvarnapur, and after notice to the petitioner and opposite parties 5 to 14 and giving them a hearing, the recent order shall be passed not later than 14th August and be communicated to the parties within a week thereafter. The court clarifies it as not expressed in here.
Item 20 actually
Item two.
arises out of the interlocutory order. Now the main writ application has been disposed of after hearing part. I have filed the order.
20, Your Lordship, the matter has become infructuous.
Correct, correct. That's what he says. Copy of the order dated 15th May 2023, disposing of the main writ petition itself, has been placed before the court. In that view, the matter, the writ appeal is disposed of as having become infructuous.
Item 21.
21 direct payment college Sarath Parade.
Sorry?
Sarath Parade direct payment. College.
Direct payment college, same one. All right.
Item 22.
22, 23, 24, same.
22, 23, I am responding.
24 also same.
24, my lord.
Same order, sir. You're sending it back.
I will file Binam on behalf of the opposite party.
That you do, sir. Just put down his name. All right.
25 also same. my lord.
Same 25. All right.
Item 26.
May the input order is at page 61. On 14/10/2006, were directed to face the for verification of documents. He did not appear on the ground that he has not received the call letter. After lapse of that validity of select list, he approached the tribunal, and during pendency of the tribunal was abolished. One of the single judge has held, as he was issued with the call letter in late, you consider his case for appointment. That's a contractual appointment, and that select list lapsed after 1 year.
No. What to provide? Okay. The notice returnable. September. There should be stay in the middle of the impute order.
Item 27.
The lordship fixed to
I've given the
26th September.
He accepts notice, same order.
I have given the appellate now.
Or
On behalf of respondent one.
or on behalf of respondent. All right.
Item 28.
May I please? Well, input order is at page 13. Sorry, well, page 11. At two dates are important, my lord. He retired on 31/7/2015. So that criminal appeal was put up on 17/3/2021. And your lordship say that rule Rule 49(5) of process pension rules, my lord, it speaks that 1 year after disposal of the criminal case. Lord, may I read that rule 49(5)?
But you have not filed a revision petition.
Hello?
You never filed a revision petition.
The revision petition has been filed in the meantime, but even if that.
No, when was it filed?
That I'm saying that criminal appeal was disposed upon 17/3/2021, my lord.
Correct.
But honorable single judge had directed to give him interest from the date of.
No.
Yeah, Lord,
5, para 5.
Yes, my lord. Since admittedly no revision has been filed by the has already been disposed upon for more than one.
So when was revision filed?
Yes, I have given that number, my lord. Is that in fact that revision number is 147 of 2023.
23.
My lord.
So it was not filed within a year.
No, but he's entitled from 1 year after, my lord, date of judgment is 17/3/2021.
Correct.
Not before that, because if there is lapses will come after 17/3/2022, my lord. If 17/3/2021 is accepted, my lord, then he is entitled to interest after 17/3/2021, 1 year after 17/3/2021.
That's only a time for filing revision, sir.
No, I am not that. I am not on revision, my lord. He is entitled to interest after only 17/3/2022 only. Not before that, my lord. May I read, my lord, rule 49(5) I am reading, my lord. Where the sanction of delayed for more than a year from the date of due as the case.
Have you released all the retirement benefits? Let's be clear on this. Have you released the admitted sum to him?
That has not been. So he's entitled.
The point is, because some interest for some extra period has been ordered, you don't pay him anything.
For us, pension has been released, interest part.
No.
I'll take instruction on that part.
The appellant will first satisfy this court that the retirement benefits and the admitted amount of interest has actually been released to the respondent.
Yes,
before this court can entertain the present appeal. At the request of counsel, the appellant list on 17 July.
Item 29.
29, well, I am for the opposite party. And in similar matters, the government has already implemented in respect of district treasury Jajpur, Kotak and Kendrapada.
No, madam.
I am
wrong information. That wrong
Keonjhar district, madam.
Wrong information.
You also kindly see. The order kindly have a glance.
First, allow him to speak. When you try to preempt him, this is what will happen.
What has happened in this case, Honorable Single Judge had directed to antedate his regularization that may I draw my lord's notice to that order of the Honorable Single Judge. You can find it from page 10. Honorable Single Judge has relied upon the order passed in earlier case filed by him before the State Administrative Tribunal. If your lordship will turn to that read petition filed before the Honorable Single Judge, your lordship may turn to page 61 of the read petition. That order, that is the order of the tribunal. In compliance to that order of the tribunal, we regulate his service at page 62, annexure 18. Your lordship may see annexure 18. That is the, your lordship can find it from page 62 of the read petition, my lord.
Yes.
15/3/2018.
Right.
there his services was regularized in compliance to the act. He filed a contempt there saying that since that order has not been complied because the tribunal had directed to regularize it with effect from 2011. That was not the direction. Your Lordship has seen next page 64, madam. That contempt was dropped, that order has been complied. Your Lordship has page 64. He did not challenge it. Again, he filed a representation that you regularized me from 2011 and in accordance with the resolution of the government. That was rejected. Honorable single judge has said, since the tribunal has directed to regularize him in accordance with that resolution, to regularize him from the date he has completed 6 years. Even if that resolution does not say, that will be effected prior to issuance of that resolution. But that resolution says that on completion of 6 years as from the date of issue of the resolution, not prior to that date. And the tribunal order, in our case, we have not regularized in accordance with that resolution. By virtue of direction of the tribunal, we have regularized, and he has admitted it, and the contempt petition has been dismissed. That order has been complied. No further direction can be given to antedate his regularization.
No, but was this brought to the notice of the single judge?
Yes, my lord. The honorable single judge had relied on that order, my lord. That was the part of the counter.
Yes, sir.
Kindly have a glance this order which I have given. And it was anti-dating regulation with effect from 2014. Though the order was passed in 2023 by virtue of the order of this honorable court. In respect of Cuttack, Jashpur and Kendrapada, 3 district treasury has been already regularized, anti-dating the regulation. I am in the district treasury Keonjhar as a peon.
What do you say to this?
Your Lordship, see what is the difference I am showing, my lord. Your Lordship, see that order of page 17.
17 of
my writ appeal, my lord.
Yes.
Paragraph. Accordingly, the Treasury Officer, District Treasury, Keonjhar, Opposite Part number 3, directed to regularize the service of petitioner with effect from 29/9/2011.
These orders are all for 2014.
Yes, my lord.
2013.
And they stand on different footing. And he is not disputing that he has not approved the tribunal. And he is not disputing that there is an order of the tribunal. And we have regularized his service.
Anyway, notice he accepts notice. Counsel for the respondent seeks to rely on office order dated 22nd March 2023, issued by the District Treasury Officer Office Cuttack, granting regularization of service to one Shri Deepak Kumar Behera, contractual peon, with effect from 18 November 2014, and 2 other similar orders on 24th March 2023, and submits that the case of the respondent here is no different from those cases. Paragraph. Counsel for the appellant, however, contests this and states that against that the respondent had earlier approached the Orissa Administrative Tribunal, bracket OAT, and had sought the very same relief of regularization with effect from 29 September 2011. Full stop. When the regularization was granted with effect from?
With effect from, my lord,
15/3/2018.
15/3/2018, the respondent is stated to have filed a contempt petition in the OAT, which came to be dismissed. Full stop. Mr. Kuntia states that thereafter, the fresh writ petition was filed when the representation of the respondent was rejected. Paragraph. It appears that the case would have to be examined in some detail. There should be stay of the impugned order till the next date of hearing. List on 3rd August.
Item number 30. 30 is rehabilitation
There should
assistance
be a
scheme.
stay of 30th order till then. Sorry.
Rehabilitation assistance scheme 30th August.
30th August. Stay.
31. That is a job contract for 14th of September.
14th September.
32. 32 may please adoption. Impugn order is at page 64, my lord. the respondent had come before this honorable court challenging the order of dismissal and the order passed by the appellate forum and to direction to reinstate him with full financial benefit, my lord. Our ground was that he was dismissed from service on account of 9 black marks, my lord. Here
On
the
account of
9 black marks during his service, my lord. Lordship, may kindly see page 65. The learned single judge relied upon an order passed by the tribunal and directed that the black marks cannot be permanent and disposed of, setting aside the order of dismissal as well as the learned appellate court's appellate authorities order, my lord, and directed him to regularize with financial benefit. This order, which has been relied upon by the honorable single judge, was challenged by the state in the SLP, but that was dismissed on the ground of limitation, keeping the question of law open.
Okay.
In a similar case, we have challenged the same relying upon the same order passed by SAT. 2 other writ petition has been disposed of. We have challenged before the Honorable Apex Court, and the Honorable Apex Court has stayed this proceedings. That is our ground that the permanent black marks cannot be permanent. That's the only ground on which it has been.
all right, notice returnable. 3rd August, there shall be stay of imbue not.
Okay.
33.
But 33, 34, rehabilitation 30th August.
30th August.
35. Item number 35.
Nana Pestis.
Item number 36.
36.
My lord, 35. My
Yes.
lord, W35. Death
Yes.
of a minor boy who was reading in class 5th by electrocution. My lord,
And defects, you cure the defects. You say list on 3rd August, defects we cured.
my lord.
Item 36.
36, 30th August.
30th August. All right.
Rehabilitation.
Item 37.
May I please, your lordship?
Defects again. List on 3rd August, defects we cured in the meanwhile.
Item 38.
Defects again. List on 3rd of August, defects we cured in the meanwhile.
Item 39.
What's in item number 39? I am for the appellant and the matter has become infructuous.
All right, disposed of as infructuous. Right.
Item number 40.
May it please the lordship.
You are for IIT.
No.
Who's for the IIT? Siddharth Das. Where is he? You say Mr. Siddharth Das is shown to be appearing for the press. There he is. That's all right. All right.
I mean, you will. Now, here we are appearing for IIT. The matter has actually become infructuous because he has already joined an IIT Kharagpur.
Oh.
He was on a contractual post, and we, at the end of his contract, we terminated him simplicity. It was a termination simplicity. Thereafter, he challenged it, my lords. A judgment was passed by the Honorable Single Judge. Thereafter, my friend is a writ appeal before your lordships. He's already, in the meantime, he's already joined the IIT Kharagpur. After a due interview, he has gone a judge. So this matter becomes infructuous.
That information I don't have. I still have the information, in fact, to pursue the writ appeal, Ballad, because the order.
Okay, that's pointless, sir.
Now, the thing is that, Ballad, he was when there is an advertisement.
No, if he's working in some IIT Kharagpur.
In fact, last time he met me there, Ballad.
What was the last time? When was that?
Ballad?
When was that?
No, that was about a couple of months back, Ballad.
So you find out. So we'll counsel for the IIT.
Now, what I'm saying, Ballad, your lordship may keep it up, then after making vacation, I'll take instruction.
Bhuvaneshwar informs the court that the appellant has in fact joined IIT Kharagpur after a due process of selection. Bracket counsel for the learned senior counsel for the appellant, however, does not have seeks time for instructions. At his request list on 3rd August. 3rd August.
Even otherwise also, Ballad, the judgment of the Honorable Single Judge needs interference.
Okay.
And but there is otherwise, that will be staring at other cases, when those things are decided.
We don't.
It's
All
that.
right.
Yes,
All right.
deep
Okay.
life.
Supplementaries for orders, item number 1, CMAPL 798 of 2022.
But it is for restoration of the ARBP number 62/18. And 23/4/21 it was dismissed for default. Both parties are absent matter. And due to during COVID-19 matter. And after that matter, also the counsel who was conducting this case, he was suffering COVID-19 cough and cold, and he filed the petition on 23/12 my lord, 22. There is a limitation my lord. And written notice of government has been already filed my lord in case the arbitration proceeding.
Again, notice will have to go to all of them, sir. Earlier they were appearing.
My lord, Mr. ST was appearing for the opposite parties. Now he has become the members in the State Consumer Dispute Redressal Commission.
It will have to go again. Note
I will
this
take-
application notice will have to go, sir.
Well, I will take notice.
Notice returnable. Eleventh August.
7th August.
11th.
11th. Obliged.
Item number 2.
I am to the opposite party.
He said that he will file.
Yes,
counsel.
Mr. Rao.
This is application for appointment of arbitrator.
I think now we can appoint this that.
We will twice you have taken time, so I will not stand on the way, my
Yeah,
lord.
yeah.
I am suggesting the mayor Vishwajit Mahanti or the Pramod
Any
Patnaik,
senior
anybody
advocate?
can.
Any senior advocate? Mr. Manoj
12
Mishra?
12 crores, 43,000 there, so it is better to appoint give
12
judge.
crores, sir. Why senior? Justice Vishwajit Mahanti, the court points to Justice Vishwajit Mahanti, former judge of this court, is sole arbitrator to adjudicate the disputes between the parties, including their claims and counterclaims.
Obliged, ma'am.
The arbitration will take place under the aegis of the arbitration center.
Item number 3.
Item number 3, your lordship, we are for opposite.
Yes.
We are appearing for opposite part number 2 and 3, your lordship.
Opposing?
Opposite part number 2, your.
No, you are opposing or?
Yes, lordship. We'll file our counter.
All right. Counsel for the opposite parties 2 and 3 seeks and is granted 4 weeks to file reply. Joined for the next date, 11th August.
Obliged.
Item number 4.
May I please, I have already served 4 sets of extra copy on the Law and Additional Standing Council.
Today's one
on 25th April 2023.
Lordship can just one more chance.
Last opportunity to file a reply
Yes,
within
yes.
4 weeks. Rejoined for the next date, 11th August.
Item number 5.
My lord, yesterday we have entered appearance. I pray 4 weeks time we are going to file a reply to this.
All right. Reply we file within 4 weeks. Rejoined for the next date, 11th August.
Rest admission item number 1, CRLMC 1358 of 2004.
On behalf of Mr. Sharma, the matter has become infructuous, your lordship.
All right. Disposed of his infractions.
Item 15 was also same.
All right. 1-5.
1-5, yes, sir.
Right.
Item number 2.
None appears dismissed.
Item number 3.
Same out.
Item 3, my lordship, kindly be taken up after vacation.
Why?
My senior is not there, my lords.
Your senior is in?
He is out of town. my
You
lords.
tell us what this is about.
Lordship, the matter is regarding, they are alleging that there is some discrepancy in the tender process in my lords. And the similar matter has already been disposed of by this honorable court, which is also reported in 2021 volume 2 OLR, page 844, my lords. And this petitioner, my lords, he is not at all involved in the process of selection. And he is the member of the committee who just recommends the name of the.
Charge is framed or not yet?
This is CBA matter.
So
this is CBA matter. They have a separate counsel.
The Lordship, I am appearing on behalf of Mr. Sarthak Naik, counsel for CBI. Mr. Naik is on his legs in another court right now, Your Lordship.
What is that similar order?
Similar order is 2021 volume.
What is that order, madam?
That in that order, this honorable court was the charge sheet and cognizance
Against the co-accused.
against the co-accused.
Okay, counsel, the petitioner claims that by a separate order reported in
2021 volume 2 OLR page 844.
The case against the co-accused has already been quashed by this court. Counsel for the CBI is some personal difficulty today. Let's go to the roster bench. 10th August.
Obliged, my lords.
Item number 4.
None of this is dismissed.
Item 5.
Same order.
Item 6.
Same order.
Item number 7.
Same order.
Item number 8.
Same order.
Item 9.
Same order.
Item number 10.
May it please your lordship, may be permitted to raise all the pleas at the time
All
of
right.
framing of charge.
All right. Permitted.
Item 11.
Same order. None of this. Sorry. None of this. Correct.
Item 12.
Item 12. Though other side has already entered appearance and as per time was granted to file reply. Here, my lord, find this is purely civil dispute and has given a criminal favor. That my lord will find I filed a suit for permanent injunction. In that suit, he entered appearance.
So it's 467, 471. How can it be similar?
The landlord and tenant, dispute between landlord and tenant. I am present petitioner is the tenant. He filed a suit for permanent injunction. Status quo order was passed. He violated the order. After violation, I filed a violation miscase. During pendency of the suit, she filed a written complaint before the land SDGM, which was subsequently sent under section 156(3) CRPC for registration of FIR. His allegation that on the basis of which I am in possession, that agreement, house rent agreement. Though house rent agreement was executed between me and her husband is dead now.
Fabricated documents. You file a civil suit on the basis of fabricated. That's the allegation is that you file a suit on the basis of fabricated documents.
Yes, because that document,
is a civil dispute
that
then?
document was executed her father, her husband. After death of her husband, she
Charge sheet filed, sir.
No instruction.
All right. Permitting the petitioner to resolve peace at the appropriate stage.
Yes.
The petition is disposed. All right.
Item 13.
None of this dismissed.
Item number 14.
14 my lord can be taken after vacation. No, because of my senior take accident, now I'm hospitalized.
All right. Counsel, the petitioner is stated to be unwell. List on 28 June.
My lord.
Item 16.
It's defectively cured in the well.
16.
No. Acha.
15th has been withdrawn.
Yeah, correct. 16. All right. None appears dismissed.
Item number 17.
May I please your lord. One of the petitioner challenges order of rejection of discharge and which was subsequently confirmed by the learned session judge. Your lordship, the case was instituted by the police and subsequently a final report was filed by the police stating that no mistaken of fact. Thereafter, a complaint petition was filed in which the learned court below has took cognizance. Twice notice has been issued.
Trial must be over, sir.
No, my lord, trial has not been over. I have filed
No. What is the stage of trial?
My lord, no instruction.
This is Explosive Substances Act and all that, sir.
Yes.
No, my lord.
What do you say? No.
No, my lord. This is not explosive substance.
Which is this CRLMC 979?
No, my lord. It is 166/2021.
You're comparing the wrong matter, sir. What is called out is 979. 17 has been called out. Item 17 has been called out.
Sorry, my lord. Sorry, my
You
lord.
just can't simply appear in some matters, sir. What is
Sorry,
this?
ma'am.
None appears dismissed.
Yes.
18. 18.
Sorry, my lord. This is my matter. My lord, this is the matter. The police filed final report first. Thereafter, the OP number 2 has filed a complaint petition, and twice notice has been issued. I have furnished the correct postal address before your lordship, my lord. Notice has issued twice, but return answer as address left. I have now I am furnishing the correct postal address, my lord.
By this time that case could have got over, sir.
No, my lord. That
Yes.
case has not been over.
No.
charge has not been framed, my lord, as per my instruction.
That's because of this pendency in the present petition, sir.
My lord, the occurrence was occurred in the year 2004 and the complaint petition filed in the year 2012, your lordship.
Correct, correct.
And now, my lord, it is the fact of the case is that at the time of alleged occurrence, the opposite party number was not
All right.
the owner of.
Despite notice being issued twice to the opposite party number 2, it has not been able to be served because of absence or incorrect address. Permitting the petitioner raise all pleas at the appropriate stage in the trial court, the petition is disposed of.
My lord, it is
The interim order is vacated.
it is challenging discharge, my lord. There will be no.
All right, but at this stage of trial, all right. At the stage of trial, all right.
Item 19. Item number 19.
None appears dismissed.
Item number 20.
Same order.
My lord. NCB, my lord.
I am opposite party.
The opposite party, all right.
My part.
Item 20.
None appears dismissed.
21.
May please, Your Lordship. But by order dated 21/4/22, that notice was issued to the opposite party number 2, was the complainant in the FIR. As it appears, the AD has not been back.
Awaiting the petitioner to raise all pleas. All right.
Item 22.
OP number 2, daughter-in-law leaving us has invited second marriage. So 498, we're pressing for quashing because she has invited second marriage and residing somewhere else. That is why she is not resided. So we may be permitted to raise all these points.
Permitting the petitioner to raise all pleas. Right.
Item 23.
None appears dismissed.
24.
Liberty may be granted, my lord.
All right. Permitting the petitioner to raise all pleas. All right.
Item 25.
None appears dismissed.
26.
No instructions, ma'am.
No instructions dismissed.
Item 27.
None appears dismissed.
Item number 28.
None appears dismissed.
29.
Not dismissed.
Item number 30.
Not present.
Not pressed.
Item 31.
So, my lord, on behalf of SK Bhanto, so can you take on the matter after vacation? As he has some.
As he has?
He's suffering from fevers.
What's the matter about, sir? Let's just see.
So, she has instituted to take time.
No, that's all right. We'll just see what it is. Just put down his name. All right, permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed.
Item 32.
None appears dismissed.
33.
Same order.
Item 34.
Same order.
35.
Same order.
Item 36.
Same order.
37.
Get to raise on the question.
All right, permitting the petitioner to raise all pleas.
38.
Same order.
39.
It's a case of compromise, my lord. Alleged offense under section 417, 493, 312, 294, 323, 506. My learned friend also entered appearance and instructed to appear on his behalf.
Where's the petition? Where's the affidavit?
No, that is.
He wants time for that. All right. Counsel appearing for opposite party number 2 seeks time to produce the affidavit evidencing compromise between the parties. List before the roster bench. 12 July. Sir.
Also. Item number 40.
None appears dismissed.
41.
Yes.
31, I am challenging the order dated 8/11/2021, passed by learner additional session judge in racial revision 100 of 2021. It is my limited prayer
let it be the gold ornaments with us. Agent will look at, then I will proceed before the court. Trial court.
See page 22. Yes, even the reasoned order. Page 22, your lordship may kindly see paragraph 10.
Dacoity. Pledged documents before the petitioner.
In the locker minor of a nationalized bank, he has directed. Page 10 of the order at page 22, paragraph 10.
So what is wrong with that, sir? Let it be in a, with a
Yes,
nationalized
ma'am.
bank in a locker. It won't be
Yes,
misappropriate. It's a fair order, sir.
Ambala by judgment, it is also applicable in my case. My lord. Due to
Well, that decision has been taken note of.
By the impugned order dated 8 November 2021, the learned third additional session Judge Cuttack has dismissed the petitioner's criminal division number 100 of 2021, thereby affirming an order dated 29th April 2021 passed by the learned SDJM Sadar Cuttack in criminal miscase number 31 of 2021 arising out of GR case number 1426 of 2020 in connection with Lalbagh PS case number 294 dated 19/11/2020, whereby the petitioner company was seeking release of the jewelry in question, which had been seized by the police and the learned SDGM had directed the concerned IO to keep the seized gold articles in a bank locker, a nationalized bank. Full stop. The factor that weighed with the trial court was that the real owners of the seized gold ornaments were yet to be ascertained.
Yes.
And moreover, they were not shown to belong to the customers of the petitioner either. Stop. As regards having to produce the seized gold articles before for the purpose of audit, the learned third additional session judge had clarified that open quotation, the copy of the seizure list supplied to them by the IO during seizure can be produced before the audit authority, and the physical production of the seized valuables is not necessary. Unquote. Paragraph, having heard and counsel for the parties, the court is unable to find any ground made out for interference with the impugned order of the third additional session judge or the trial court. The revision petition is accordingly dismissed. The present petition is accordingly dismissed. All right.
Item 42.
None appears dismissed.
Item 43.
None appears dismissed.
Item number 44.
Same order.
45.
My lord, here the final form is accepted and the case record is closed by the learned court. I am filing this order.
So it's infructuous. All right. In view of the subsequent development where a closure report has been filed, the present petition has been rendered infructuous. It's disposed of as such.
Item 46.
None appears dismissed.
46, my lord. I am for item 46, my lord.
Yes.
Liberty may be granted to raise all those points at the time of trial, my lord.
All right, all right.
Obliged.
47,
None appears dismissed.
48,
Same order.
49,
Here we have challenged the registration of an affair. Incident arises out of it's a college named Regional College of Management. Dispute was regarding the governing board. That issue has been settled. We are now the governing body recognized by the High Court.
So it's infractuous.
No, not infractuous. What has happened is an abuse. Abuse in the sense, my affair is first. I lodged an affair under annexed 4. Kindly see page 30.
Who's appearing with the other side?
Well, the notice had gone. He's left the address.
Then
So I'll take another notice. Let it come.
why chase? It will automatically die, sir.
No, what is
He's an employee. He may not be interested
he's
in
not the
pursuing.
employee. The dispute.
No, whatever. He may not be interested in pursuing it any longer.
The whole difficulty is not against one person. Here, I am the managing trustee of the college.
All right.
No overtact alleged against him.
So
Now-
maybe nothing will happen, sir. What's the status?
Unnecessary. Why should it linger, man? Why should I face the trial? It should be
No,
quashed
where's the
against
question of
me, so
trial?
far as I am concerned.
What is the stage?
Then nothing has been done. It's just
Then
like
where's the question of trial? Maybe there'll be a closure report, for all you know.
yes, maybe they'll let them get the instruction. 2 years they are not getting the instruction.
No.
What has happened? They must say that whether it's a file charge sheet, not file charge sheet, closure report.
Virtually, you got an anticipatory bail here.
No, my lords.
Of course.
I am the
This
victim, my
simply
lords.
says-
I am the victim, my lords. I have lost the affair. My guards have been beaten up. They've also lost affairs. And now he
All
filed an
right.
affair.
Counsel for the state needs time for instructions on the current status of the investigations. Interim order to continue. List on 21st August.
get to item 50.
So on behalf of SK Bhantos.
Same.
50, 52, 53, 54.
All permitting the petitioner raise all things in the proper stage. All right.
51,
None appears dismissed.
51.
Yes, Mr. Mishra, 51. All right. Pass over.
Item 55,
None appears dismissed.
56,
Same order.
item 57,
Same order.
58,
My lord, initially the charge sheet was filed under section 493, 417, 354A, 526 IPs, my lord. But when the court took the cognizance, my lord, they added under section 376, my lord. But I challenge before this honorable court, that is in CRLMC number,
Page 31.
my lord, CRLMC 2706 of 2017, my lord. When the stay was granted and the case was pending before your lordship, my lord, they took the charge, my lord, that is charge I have given, that charge deleted that 376, my lord. And after all the witnesses are examined, my lord, 18 witnesses are examined, my lord, case posted for accused statement, my lord. Your lordship may kindly see the order. After the accused statement, my lord, page your lordship may kindly 31, my lord, 2 orders, my lord. On 24/3/2023, my lord, the case was posted for accused statement, my lord. And on the latter, my lord, on
any stage of
on latter, my lord, latter part it said that 376 is reframed, my lord. Though accused was not there, my lord. So 376 was reframed, my lord, basing on the improved statement of the victim, my lord. And that is duly confronted to the IO and duly confronted to her, my lord. That is not in FIR, not in 164 statement or not in 164 statement, my lord. But only basing on that, my lord, 376 was added, my lord. That is why I have come before.
No, but now the trial must be over.
Trial is, my lord, for accused statement, my lord, for your lordship.
So let it come to an end, sir. Let it come. You see, the trial action appears to be concluded. The examination of prosecution witnesses appears to have been concluded. And the stage is at the recording of the statement of the accused under section 313 CRPC. The court will therefore not like to interfere at this stage. It will always be open to the petitioner to raise all his pleas in the trial. The petition is disposed of.
A case to be tried in de novo, my lord. That is
obviously from whichever stage it is, it will continue.
From 59.
59 not pressed, my lord. 59 not pressed.
Dismissed as not pressed.
My lord, I may pardon. One small prayer, I was held up in court number 7 in division bench. I was arguing in one appeal. 2, 8 and item 2, 8 and 38. 3 matters are default well. Yesterday 4 matters were there. And day before yesterday 2 matters. My lord has adjourned to default well matters to 27-6.
All right.
2, 8 and 38. 2, 8 and 38.
All right. 27.
27. 2, 8 and 38.
All right.
Okay.
Item 60. May I raise all this point before the trial court at the appropriate stage, my lord. My lord. Item 61.
None of this dismissed.
62.
Alright, there is the case matter 307. FIR has been lodged as against the petitioner under section 307. And the informant and the present petitioners both are employed in the same place. And there is a dispute and the matter has been compromised between the parties. And that has been evident in the order sheet. Lordship kindly turn to page 17, second para.
It's all unreadable, sir. Is there a defect pointed out or not?
Well, defect is pointed out.
First cure it. You cure it. See, list on 28 June, defect be cured in the meanwhile. All right.
Pardon, your lordship. Lordship, item 61, your lordship. Lordship, I pray for 1 minute time to remove the defects, your lordship.
All right. Same order in 61. All right.
Yes, sir. Oblige, your lordship.
Item 63.
None appears dismissed.
64.
Same.
Item 65.
Same order.
66.
Criminal dispute, my lord. Matter is almost compromised between the parties. So seek some time.
All right. Counsel of the parties want time to produce the affidavit. The compromise terms. There's already an affidavit.
No, my lord, Gold has returned, but other articles has yet.
So we need time to work out the compromise. This is the roster bench on 28th August.
Okay.
All right. Memo taken on record. Permitting the petitioner to resolve, please. All right.
Item 67.
67. Matter has been compromised. Opposite party will appear and file
I am
affidavit.
appealing for opposite partner 2 on behalf of Mr. Santosh Kumar Mohanty. The matter has already been
Affidavit is there.
compromised.
Flag B.
All right.
Settled.
Counsel appearing for opposite party number 2. What's the offense, sir?
354, 457, 376.
I had a complaint case.
376.
My lord, sister-in-law and a brother-in-law. That brother, sister-in-law lost their affair due to the civil dispute.
You want to check out, sir?
I was not a complaint case.
376.
Counsel for the.
And also cognizance has been taken at page 8, your lordship.
All right. Counsel for the state will verify the genuineness of the affidavit filed by opposite party number 2 and inform the court on the next day. Let's go for the roster bench on 11 July.
Item 68.
Please, ma'am. Petitioner is the Assistant Commissioner Commercial Taxes Millards, who has directed issue of registration certificate to some of the co-accused on the basis of the inquiry report of the CTOs and ACCTs Millards under him. For that, he was subjected to a departmental inquiry in which he has been exonerated. And thereafter, my lords, in the vigilance case which was instituted in the affair in which he was not an accused, he has been charge sheeted on that basis. My lords may see at page 92 of the brief. There is a chart showing a list of officers of Commercial Tax Department. And thereafter it is stated at page 93 that the commercial tax officials mentioned by its serial 2, 4 and 5 of the given table who are at intermediary level have transmitted inquiry report of the inquiry officers in the RC record of dealer applicants to higher authorities and have not taken any active part in statutory inquiry or
Mr. Pandey,
issuance of.
all this can be raised before the trial.
Lords, I have got nothing at all to do with this, my lords. On the basis of inquiry reports, my lords, I signed the registration.
But this can be argued before the court. All I'm saying is you raise it in the stage.
And these same allegations have been exonerated in the departmental inquiry.
Pointed out, sir. Permitting the petitioner to raise all pleas at the stage of charge. The petition is dismissed. The interim order is vacated.
69.
None appeals dismissed.
70.
Your Lordship, in item 7, the matter has been compromised. This is a matrimonial dispute, Your Lordship. I'm for the opposite party number 2.
Oh, you're for opposite party?
Yes, Your Lordship. The affidavit is at flag A, Your Lordship.
All right. Counsel appearing for opposite party number 2 confirms the affidavit filed by her stating that she does not wish to pursue the matter and that the dispute has been amicably settled between the parties. The marriage also appears to have been dissolved through mutual consent.
Much of
That view of the matter, take the prayer clause and all proceedings consequent that we have approached.
much of this.
71.
None appeals dismissed.
72.
None appeals dismissed.
73.
May I please your lordship?
Yes.
My lord, matter family because of family dispute or proceeding initiated. In the meantime, opposite party appeared that matter is likely to be settled. My humble prayer before your lordship, matter may set to the.
All right, Mr. Consulas. All right, the petitioner states that the matter is likely to be settled with the opposite party number 2.
Already appeared. I have also taken consent.
No. Today nobody is appearing, sir.
Already appeared today, not present.
Yeah. At his request list. Roster bench on 7th August.
Interim order may continue, my lord.
Interim order to continue.
74.
I may be permitted to withdraw, my lord.
Dismisses withdraw.
75.
My lord, I am appearing for opposite party 2. My lord, I have filed the affidavit at flag 2. Kindly say paragraph 5. Although compromise petition has been filed, but the opposite party number 2 apprehends that in the event it is dropped, then they would withheld themselves from payment of alimony.
The application has already been filed. It is posted today, Your Lordship.
All right.
And
at
it
the
is
request of
posted
counsel, the parties listen to the roster bench on 7th August. Interim order to cut. All right.
Item 76.
Liberty may be granted, my lord.
All right. Permitting the petition raise of this.
77.
Same, my lord.
Same.
78.
I may please your lordships. My lords, here is a case, my lords. The petitioner is the husband and the OP number 1 is the wife, my lord.
Mediation failed.
Yes, mediation report is there. I don't know, the 2 reports are there. Flag C and flag D. Your lordships. Nothing is that. I have not know. Report has not been served on me, so I don't know.
No, it is adjourned to 1st March. And then what happened?
No copy has been served.
No, you are not the party. You are the DB case. DB case.
The last report of the mediation center is
Yes.
that mediation had been adjourned to 1st March. A further report be requisitioned from the mediation center. List on 9th August.
Interim order to continue.
Interim order.
Okay.
Item 79.
79 permitted to withdraw.
Item 80.
Hey, please, your lordship. So this is a case for crossing of the affair, my lord.
At my submission, my lord, the offences are totally not made out according to FIR, and also one witness statement, my lord. None of the offences are not made out, my lord. Last offense notice was issued.
In this case, charge sheet has been filed and
Yes.
cognizance has been taken.
Raise all, please, sir. Permitting the petition to raise all, please, with the appropriate stage. All right.
My application's been noted in OP. I am
Okay.
appearing for OP2, my lord.
All right.
Item 81.
Lordship, in this matter, I am for the petitioners.
Yes.
Lordship has issued notice in this matter on 18th January, and the subsequent date was listed for 12th February. It was not listed, and state
What's
councils
it
were
about?
asked to file the reply and instructions.
What is the matter about, sir?
Yes, Lordship. The matter is it's a allegation of 379 and Section 12 of Orissa Mineral Theft Prevention Act 1980. Here the case is the land in question is a homestead land. He has purchased the land on his own land while he was working for the construction purpose, for foundation purpose. His JCB was seized and he has been reported as a theft of mineral. While the land in question is a private land and he's working, he's doing the construction. That photograph.
What's the current status, sir?
My lord, the Tahsildar has filed this report against the present petitioner. He was lifting illegal soil from the land of from government land.
From government land?
Yes,
No, no, no. His own land?
Lordship, not.
His
not
case is
government
that
land.
it's his own land. No, charge sheet has been filed.
No instruction, my lord.
You better get it.
Yes, sir.
Counsel for the state seeks more time for instructions on the current status of investigations. List on 12th August. Sorry, not 12th, 16th August. 16th August.
Item number 82.
None of this.
83.
Same. All right, he's for the opposite party.
84.
None of this.
85.
In this case, your lordship, the petitioner has challenged the cognizance order of the against the petitioners under section 351, 294, 323, 354, 336, 307. The petitioners is wrongly implicated in the case because they have taken water from a channel and the informant registered. For that reason, there is a civil dispute between the parties and the affair has been lost. During in the affair, there are only allegation that the petitioner throws some stone and it has been hit to the informants.
So I am appealing for the opposition 2 minors. The petitioner raised pressed the neck of the petitioner and also assaulted by means stone minors to the granddaughter of the.
So you're opposing?
Minors, I am opposing minors.
Permitting the petitioner to raise all pleas in the proposal. All right. Let's
I'll
put down his name for opposite party. Yes. All right.
Pardon, Lordship. Lordship, item 87 I just missed, Lordship.
No, we are not called it out yet.
86.
I'm obliged.
86.
86, my lord, some time is required to file the reply affidavit of the counter filed by the opposite party number
Just
2,
tell us
my
what
lord.
it is. What is the matter about, sir?
376 to N, my lord.
Matter regarding my lord, due to love and affair, both are each other.
No settlement, sir. That's the whole problem.
My lord, taking out the disadvantages of the petitioner, my lord, the opposite party going to torture me physically and mentally. Thereafter, I have made another affair against him, her, my lord. Kindly see the.
So you are very far from any.
She demanded more and more money to.
All right. Permitting the petitioner raise all pleas at the appropriate stage.
My lord, liberty to.
Yeah, that's what you said.
My lord.
87.
Dispose of, my lord. My lord, I'm petitioner dispose of.
Disposed of.
Yes, ma'am.
Item 87.
Yes, may it please your Lordship, my Lord.
Yes.
My Lord, this present petitioners has preferred these applications that affair has been lost after same ground for 2 times, Lordship. But the police report says that this petitioner has no involvement. Last time stay was granted, report was called for. He is a doctor basically. His compounder has lost a wrong thing when he is out of his service. That is what the allegation. Something is there, my lord. My lord, in that case, report was called for, whether it is a mistake or fact or not.
Who's appearing for opposite party number 2? He's been implemented. I think the complainant has been implemented.
Yes, Lordship.
Has notice gone to him?
Yes.
No.
My lord, complainant has not been implicated on the first instance. Later on, we were served the copy. One person has entered appearance, Lordship.
Who has entered appearance?
That name has not been replaced, but I have the opposite party has been added of Vikram Kishore Senapati. The order says, my lord. Notice has been issued also.
No. You are appearing in CRLMC 2718, right?
2771, Lordship.
So the case is 2718. What has been called out now? Jiten Raut.
Yes, Jiten Raut, Lordship.
That's 2718, sir.
2718, Lordship, yes.
You said 2717.
No. I'm sorry.
And the opposite party number 2, Sudipta Behra. Let's notice one. So the name of opposite party number 2 is Sudipta Behra.
My lord, the Jiten Raut, my lord, the case is already proceeded in lower court, permitted to withdraw, Lordship.
All right. Permitting the petitioner raise all pleas with the appropriate stage. All right.
Item 88.
None appears dismissed.
Item 89. May it please you, Lord.
Yes.
Here, my lord, the dispute is between my lord, the owner and the tenant. Both are ladies, my lord, for which a case of 341, 323, 294, 506, 34 has been registered. After hearing me, my lord, notice has been issued.
She's been served, but nobody is appearing for her now.
My lord.
Despite service of notice, none is appearing on behalf of opposite party number 2. What is the stage of
Cognizance has been challenged, my lord, because my lord, she stayed there. She started, my lord, some mischief, illicit work. Petitioner, who is assistant professor in kids, my lord, she opposed. My lord, the persons engaged by opposite party number 2 assaulted the petitioner, who is unmarried, my lord, spinster, staying with her mother in the upstairs. She was assaulted brutally, for which a case of 307 has been registered against opposite party number 2. Again, my lord, the police came with police. Police again initiated a case against me, my lord, being instigated by her and her boyfriends, my lord. Now, my lord, the case is, my lord, I have initiated the case that was not, my lord, registered by the police. I filed a CRLMP before this honorable court. This honorable court directed, basing upon the judgment of my lord Lalita Kumari, it was registered for the offence under 294, 506, 307 and other cases. She came with a case of 341, 323, 294, 506. It's a clear case where deliberately she is not appearing, taking it granted that.
All right, we'll just adjourn it then. It's an interim order to continue. List on 28th August.
Item 90.
This matter relating to release of vehicle, kind taken after vacation.
What is matter about, sir? Release of which vehicle from where?
My lord, vehicle Mahindra XUV 500 melon and one mobile set melon, which has seized under NDPS Act.
NDPS Act. The trial must still be on.
Yes, madam. One judgment to be pronounced, my lord. Therefore,
then it's okay. The matter is stated to be at the stage of pronouncement of judgment in the trial court. Obviously, the trial court will pass appropriate orders of the seized articles as well, seized vehicle and mobile phone as well. So, consequently, the court is not inclined to interfere at this stage. The petition is disposed of.
No, my lord. Regarding a release of vehicle, my one single bench judgment is registered, my lord.
That's all right, sir. The trial court will follow all those judgments. Yes.
Item 91.
Okay.
None appears dismissed.
92.
Same on.
92, my lord. I'm sorry, Lordship.
Yes.
Yes, Lordship. Actually, I was present in this case, Lordship.
No wonder.
Sorry, Lordship.
No wonder. Yes.
Lordship,
Yes, tell us.
yes, present petitioner is a doctor, Lordship.
Who's your appearing, sir? In this Pravas Chandra Subudhi.
Yes, Lordship.
I am. No, for the opposite party number 2.
Yes, so I am appealing, Lord.
Achha, all right.
So there is investigation. So yes, I am the informant, my Lord.
He is also
So investigation is going on, Lordship. The investigation is going on, Lordship.
My Lord has called for a last occasion, Lordship. Stay was granted. The state has given once this was a mistake of fact. This present case. Again, for same occurrence, this report was called for. What is the status? The report has not come. Probably that was the report has to come. And in the meantime, my Lord, the dispute regarding the allegation, allegation was this present petitioner has kept some gold. In that way, he has given some money. When the petitioner, the complainant wants to give that money, he doesn't return his gold. That is the allegation, my Lord. The same allegation he has raised earlier. It was a mistake of fact. The charge sheet was submitted.
No, that not Lordship. And the gold has been seized, Lordship.
Yes,
by the
from
police,
other
Lord.
person. From other person.
Whatever it may be. Yes, produced by Mr. Subudhi, my Lord.
No.
Yes, Lordship. So they are
Anyway, so we permit you to raise all pleas at the appropriate stage.
obliged, highly obliged, Lordship.
All right.
Yes, Lordship.
The
And the increment of bracket, Lordship.
Yeah, vacated. Correct.
Just Lordship. Obliged, highly obliged, Lordship.
All right.
Item 93. Well, here the case ballot is clearly covered by Byler's judgment, reported in 2022, volume 87, Oshia, page 1. And I have given a memo, my Lord. Memo, my Lord, where it on 8/5/2023, petitioner has been exonerated from all the charges leveled against him. My Lord has decided it elaborately after hearing me at length, and they are standing up, counsel appearing for the state also in that case, my Lord. Everything has been
No,
taken
my
out
lord.
of.
I'm sorry. I have something different to place. The lordship kindly see the inquiry report for page
My Lord, may see
43.
my learned friend perhaps has not gone through this. My Lord may see the memo which I have given. That is, my Lord, the order.
I have to gone through. Your lordship kindly see the inquiry report. It's a case under section Prevention of Corruption Act.
No, they've dropped the whole proceeding, sir.
No.
You better go through this. You better go through this. An order dated
And
4th May 2023 has been produced before the court, which has been issued by the ST and SC Development Minorities and Backward Classes Welfare Department, Government of Odisha, whereby the disciplinary proceedings against the present petitioner has been closed. Relying on the judgment in Dr. Miniketan Pani, the State of Orissa, 2022, 87 OCR 1. Mr. Dalal, senior counsel of the petitioner, seeks quashing in the present case as well. Paragraph counsel for the opposite party, Vigilance Department seeks time for instructions. Interim order to continue. List on 28th August.
94. 94, may I please? Your Lordship, judgment is covered to this case. My senior has already submitted. That is Minakatan Pani case. He has been exonerated from the department proceeding. That is there by us. Your Lordship may kind see.
With your lordship's permission.
No.
With your lordship's permission. So far as Minakatan Pani's case is concerned, there is another 3-judgment judgment of the Honorable Appeals Court that has not been taken care of, with all respect, my lord.
You pointed out, sir. You pointed out. You take the same thing. You say copy of an inquiry report dated 15/2/2023 has been produced before this court, exonerating the petitioner from all charges of disciplinary proceedings, relying on the judgment in Miniketan Pani. It is claimed that the criminal case against the petitioner should be quashed. Counsel for the Vigilance Department seeks time for instructions.
Like vigilance,
State, counsel of the state, all right. Seeks time for instructions. List on interim order to continue. List on 29th August.
Obliged.
95.
95, my lord. I have been requested by my sister Mahapatra. I am submitting before Lordship on same allegation. 2 FIR has been lost. That is called as a double jeopardy in view of the TT Anthony case. I have annexed. That is in the petition that has been annexed. Annexure 1, page 8.
What is the development here, sir?
The cognizance has been taken.
That is there.
Annexer 3, your
No,
lordship.
no. What about charge sheet?
After charge sheet, my lord, this cognizance.
After
has-
charge sheet. Achha.
Thereafter, another FIR, same allegation, my lord. That is not tenable, my lord.
No, no. Which you're seeking quashing of the first one or the second one?
First one.
First one, my lord.
No, no. You should seek quashing of the second one. In this, you raise all pleas at the appropriate
Yes,
stage. All right. Permitting the petitioner raise all pleas at the appropriate stage. All right.
96.
But here is case I have challenged the order of the Lord Judge rejecting my prayer for production of my minor 2 children. The mother is the petitioner and her 2 minor children is custody of opposite number 3, who is a stranger. Well, what happened, my lord? While both the husband of the petitioner and that the opposite 353 were the neighbor, and at that time the husband of the petitioner was died. He was serving in MCI. So by the help of the OP number 3, he got the service, the petitioner got the service under rehabilitation assistance scheme in the MCI. So taking that advantage, now the petitioner is in quarter, but her minor 2 children is with the OP number 3, and he has instigated to him that against the petitioner and not to come to join with him. He, the petitioner, is the natural guardian, and she.
So one of the daughters is now major.
Major, no major. Now minor. Minor.
She was 16 years and 21, sir.
Another is 13.
One is 16 in 2021.
21.
Today, what will be her age?
So you will complete it. One will be major. Just.
So
another is 13.
So the fact has changed.
Another is 13. He is minor.
No, she never grew up. She was 13 in 2021. She continues to be 13 today.
Then you will be 15 or 16, not 18.
My arithmetic is a bit weak. Yours should not be so weak.
So we are because I have challenged when the case is that at that time both were minor. Now one will be major because
you better find out. So you better find out, sir. The situation has changed.
So may I only pray that, my lord, the matter may be remitted to the CWC, Child Welfare Committee, who will guide, and the children will remain in any child home and access to the petitioner to visit, so that it will come to a light that because as long as he will be custody of the OP number 3 the children, they will not say anything because he has threatened to them.
May kindly see page 33. Page 33, paragraph 5. Like on perusal of impugned orders, it reveals that law and the SDGM Jharsuguda has recorded the statements of the 2 minor girl child. And
they don't want to go with her. Yeah.
Yes, ma'am.
So that is the matter.
Then also
because when you are seen the custody of that OP number 3, naturally who will tutor him and say will say. So that's why my independent view, the children may be kept in for a month in any children home.
What is this?
And the mother is the natural guardian is mother, my lord. And they are not getting any educational facility because I am an employee. So my department will give them facility. They are not studying, my lord. At least a report may be called from the collector. The children are not studying, not going to school.
No, very false statement.
So
in deposition, they have stated
what you have tutored, they have stated. So you have to prove. Collector will say whether they are reading or not.
These are the school admission registers and the money payment by the monthly salary payment by the opposite.
So that's why their education spoil, career spoil, and I am the natural mother. And which capacity you have kept? You are neither you are relative nor a blood relation. In which way you will keep my daughter? In what interest you are gone there, madam?
The mother has filed a guardianship petition before the civil court Jharsuguda, and that is pending. I have filed the petition along with my counter, and that is hearing stage. Their guardianship.
Pursue that there, all your pleas there.
No, that has been disposed of. That is not in pending.
Where is the order?
That is disposed of. I have no instruction. That is instruction only disposed of.
Then you produce that. Before which court in Jharsuguda? Guardianship proceedings.
That is.
Give us a number.
Court District Judge Jharsuguda. District Judge. Annexer 1 to my counter.
Counsel for opposite party number 2.
The petitioner has filed.
Certain proceedings instituted in guardianship petition number 1 of 2020 by the present petitioner in the court of the District Judge Jharsuguda. under Section 10 of the Guardians and Wards Act 1980. Paragraph. Petitioner states that the said proceedings have been disposed of and undertakes to produce a copy of the order on the next date. List on 9th August.
97.
I don't 97, your lordship, I will raise my point under the appropriation.
All right, permitting the petitioner raise all these.
98.
In 98, I'm appearing for the opposite party number 2.
All right.
I have filed my appearance and the matter has been compromised in the meanwhile. I have filed my affidavit, your lordship.
All right. The affidavit of opposite party number 2 stating that the matter has been compromised is taken on record. That is the matter. GR case number, take the prayer clause and all proceedings constant that we have.
Much obliged.
99.
My lord, on behalf of Mr. Picky, so I may be permitted to raise all the points at appropriate stage.
All right.
100.
None appears dismissed.
Pattern to mention, my lord. Item number 13, my lord. I could not appear, my lord.
Tell us.
My lord, the petition is a 68-year-old Sanskrit Pandit, my lord. He has been falsely implicated in this case, my lord. And his name is not appeared in the FIR. But at Borhampur, my lord, at South, my lord, when you are my neighbor, my lord, you will enjoy one part of my wall, I will enjoy one part of my wall. There is a agreement, my lord, come to Annexure 1, my lord. I'll turn to page, my lord. Page 18, my lord.
What's the stage of the case, sir?
My lord, the falsely implicated this person, the headmaster, my lord, is Sanskrit Pandit.
Yes, sir.
My lord, this is the FIR is registered against the daughter of this petitioner, present petitioner, and they are exonerated, my lord, from charge sheet. This person was inducted in the case on what charge, my lord? 31G. My lord, kindly allowed me to praise. Wrongly disposes a member of a scheduled caste or a scheduled tribe from his land premises. My lord, at this age, he is Harikirtan Karjun, my lord.
What is his age?
He is 68, my lord. He's a Pandit, my lord. He's a praying God.
68 is not old, sir.
My lord, he's a Sanskrit Pandit.
So what?
He come to me and I saw Sanskrit. He's always using, my lord, Sanskrit things.
So anybody who speaks good Sanskrit cannot commit any crime.
Right, my lord. But he has, and my lord, kindly go to the Annexure 1, my lord, to convince, my lord. Kindly have a glance, my lord, at Annexure 1, my lord. Page 18, my lord. There was a agreement between the vendor who has sold that land to this AC person, my lord. They both are Brahmin, my lord. They are occupied their land, they are enjoying their wall, my lord. And thereafter, there is a compromise on page 23, my lord, kindly talk. My lord, Annexure 2, kindly have a glance, my lord. The old man will be saved from moving to this court, my lord.
Don't please call him, keep calling him an old, sir. 69 is not old.
My lord can, my lord, but I saw him with you.
You make me feel very old.
No, I am not making my lord. My lord made so much transformation in our High Court, my
that's
lord.
all right.
I just say, my lord, I pray this one, my lord. This old man should not be moved to the court, my lord, because of 31G. Because of this 31G, my lord. And my lord, Annexure 2 may kindly see there is a compromise between the two parties before FIR.
Lordship have been given, please, the liberty to raise all this.
All the please. That's
nothing will be happen, my lord. If my lord permit also, the old man will move to the court, my lord.
No, that's all right. Permitting the petitioner raise all please at the appropriate stage.
There is a great hope he comes to, my lord. This old man comes to get hope. Nothing has,
No, nothing.
nothing happened.
Right.
Passport matter item 51.
Oh, my lord, grateful.
I'm in VC, my lord. I'm sorry that I got disconnected.
Yes.
Item 51, my lord.
Yes.
Some defects have been pointed out. Your lordship,
All right. You say list on 2nd August, defects be cured in the meanwhile. All right. Oh,
Wishing your lordship a happy vacation.
I'll come back to this.
For orders item number 1.
Here, if my lord would see the order number 2 in WPC 18923 of 2018, this was disposed of by way of a common order passed on 19/11/2019. That common order is order number 55. The lead case was WPC number 7939 of 2011.
Correct.
So if my lord would see the heading of that order, all those writ petitions are mentioned. This 18923 is the penultimate number. So the matter basically dealt with the prayers in WPC number 7939 of 2011. So that lead matter was disposed of in terms of the Supreme Court order. Now this writ petition, basically it was in the fresh category. That's why by order number 2, it was disposed of. Now we have given a convenience note along with a list of dates. If my lord would see, the brief reasons for recall are at page 9. I hope my lord Justice Sahu also has that. So we have listed out 4 reasons that in the batch case, the main this writ basically was never dealt with. In addition to this,
you were before the NCLT.
We were before NCLT. So the court should not have actually taken up. That was in fact reversed in Supreme Court in one of the cases.
So what has happened? Are you now still before the NCLT?
No, NCLAT reversed it. In that list of dates also we have given it at page number 8. After NCLT admitted, thereafter NCLAT has reversed it. Now it is again gone back to the pre-CRP process.
Right.
That order also we have annexed to the IA for recall.
So what is that 13740 of 2023 filed with the Workers' Union? Where is that pending now? Just see the list of dates 1/5/2023.
So that is the new writ is to restore back their own application. So that is by the Workers' Union.
No, I know. I'm just saying that it's your very Workers' Union, right?
Yes.
So that must be there before a single judge.
That was taken up by the single judge. Now it has been listed before another court because that was not the assigned court. That's what he says.
All right.
So in any case, those are not interlinked. This can
Justice
be independent.
Sahu, can we just restore it before the roster bench?
Whether it would be proper, my lord, without issuing notice to the other sides to restore it, or to let notice be issued and then we'll.
All right.
It was a fresh case, of course. The notice was never
No,
issued
because it was a
originally.
fresh case. No notice went in the petition in the first place. It was simply tagged with that other petition.
The other case might be they must be appearing. I do not know, have the other file. In this case, he's right. Mr. Mishra is right that in this
It was simply tagged with 7939, and then the judgment was passed in 7939.
Mr. Mishra, in none of the cases notice has been issued or
No,
no
no.
party has appeared.
No, in this writ, no notice was issued.
No, that is right. But I am saying that maybe that they are appearing in the other connected writ petition. That is why I am.
Subject to my lord's accepting what I would suggest, my lord may recall and restore it and clarify there that the matter would be taken up by fresh, as a fresh matter. Then the court, if it finds merit in our submissions, will issue notice. If it is dismissed, then it's
Because if they have appeared, I do not know what is. If they have appeared, they may say that they
No,
have
in
not
this,
heard anything. If any of the matters, if none of the matters notice has been issued, they have not appeared.
No,
it's well and good.
because the Workers' Union was carrying out the lead matter. So they were appearing in the lead case. So we can't say that they were not represented because their matter was the lead matter.
So let's issue notice in this IA.
My lord.
Anyway, they will appear.
My lord,
All right.
my lord may issue notice in this.
Yeah. Notice returnable. I don't know. 14 July?
My lord.
14 July. All right. Yeah.
Second IA was for delay. That's not pressed. That delay in recall that may not be required.
All right. Which one is the 7390?
The first one is the IS 7375 is the one for recall. 7390, my lord may say that there's no delay.
Okay.
Normally in these IAs, there's no.
There is no delay in filing the present
IA for
IA, and therefore the application is disposed of. All right.
In IA 7375, we'll take notice against the.
Correct.
we are all great.
All right.
Item number 3.
This case has been filed to transfer the original application, that is 1585 of 1919 mailers. Earlier there was a direction. So the file has not come, that's why the miscase has been filed, mailers. And also there is a specific direction to list the matter on 26th.
The transfer is over, sir. Once the OAT is abolished, all the matters have anyway been got transferred.
Now, in spite of specific direction, that has not been transferred to the Swarnam Court. That's why a miscase has been filed.
I think it has been renumbered. All the files have been.
Yes, all matters have been renumbered.
No, but this file has not come. That's why.
This must have been renumbered as WPC OAC.
Yes.
Just go on the net and see if there is such a reproduction at all. Oh. The registry will prepare and place a note on whether OA number 1585 bracket C of 1999 has been transferred from the OAT to this port after abolition of the OAT. And if not, the reasons therefore, in any event, the record of the above OA be placed before the court on the next date. Less than 7 July. Right.
No. For orders, item number 1.
Item number 1, your lordship. I mean, inside custody the present, there are 2 appellants. Appellant number 2 was granted bail. Appellant number 1 is inside custody since 17/8/2013, your lordship.
Pardon your lordships. In this case, I am appearing on behalf of Mr. Mahapatra for the opposite party. Your lordships, his mother just got admitted in ICU today morning, so he left. I pray your lordship, this matter may kindly be taken up any other day.
This is somebody's bail, sir.
Bail
application,
sir. As your lordship, please.
And your last day before vacation, which means person stays in jail for 1 more month. Too much. Yes. Anyway, all the co-accused have been granted.
Two
No,
there are there.
One out of 2 plus 1 have been granted bail. Out of 2, 1
All right. All right. It is seen that the co-accused has already granted bail. The present applicant has been in custody since 2013.
2013.
Right.
16/8/2013.
16/8/2013. It is unlikely that the present appeal in its usual turn will be taken up in the near future. The paper books are also not ready. In that view, the matter in view of the judgment of the Supreme Court in Singada Singh, the appellant number 1 is directed to be enlarged on bail subject to the satisfaction of the trial court during the pendency of the present appeal. This is IA 54 of 2020 is disposed of. In the main criminal appeal, you say paper books be readied and supplied to counsel of the parties within 8 weeks. The matter be included in the list of final hearing matters immediately thereafter.
Item number 2.
I may plead your lordship, what's your knowledge?
Yes, please.
The limited matter, the family pension was sought by the wife of the deceased government employee.
Okay.
And that admittedly, the government employee resigned. Therefore, in terms of the rule, forfeited the entire period of service rendered by him. But there is a provision under pension rule 46. In such a circumstances, the power vested with the employer to grant compassionate pension to the family members. That maybe Lordship, I may be allowed to.
Why is it a review, ground for review?
Exactly.
Sir?
No, 46 has not been taken into consideration. 46 has not been taken into consideration. And what I'm trying to converse with Lordship, I may withdraw the review and approach the authority under Rule 46.
No,
it's a compassionate pension matter. Family pension.
Sir, the tribunal has already taken into consideration Rule 46
and during lifetime of your husband, he had never applied for compassionate allowance under Rule 46.
That much I can advance, my lord.
Yes, that's, and
That
it
much
is,
I can advance with the lordship, my lord. This is a case of
tribunal
family
has
pension only. That's
very.
true. I have gone through, my lord.
Yes.
Still, hope compassionate pension.
It has
as
been
your lordship
rejected,
wishes,
sir.
I
It
need
has
to
been
matter to your
rejected,
lordship.
sir.
I'm aware of the position of law.
All right. No grounds made out for review. The review petition is dismissed. All right. Right. Thank you.
Application. Not sure. I was there in the link. That time, the first 10 matters in one link and second link. I was there, but it could not be heard by your lordship. And it was told by the court officer that it's adjourned, but subsequently non-appearance.
What's the main matter?
The main matter is with regard to the implementation of certain provisions of Odisha Advocates Clerk Welfare Fund Act 2008. There are certain prayers which has been enhanced. I prayed for enhancement of the stamp which has been done, but there are two specific provisions under the rule which needs to be implemented. As a result of which the advocate's clerk will be largely benefited, my lords. If your lordship may permit me to draw your lordship's kind attention at page 43, my lords, which talks about Rule 7 of the Odisha Advocates Clerks Welfare.
All right. We say for reasons stated therein, the order is recalled and this petition is restored to file.
My lord, may hear the final read.
That's right. In this writ petition, you say list before the roster bench. On
my lord, it is in form of PIL.
That's right. Okay. List on. All right. 22nd August. All right.
I'm obliged.
All right. Right. Issued. You're returning all the 41 checks.
41, and my affidavit, your lordship may kindly peruse my affidavit.
All right.
Lord, I have little submission before lordship.
Yes.
Before
Ma'am.
you lordship.
One person, by mistake, he has withdrawn the amount. He is prepared to return it back. One person. Another person, your lordship.
Who's that person?
Denudhar Parmanik. I've given in my list serial number 42. Benudhar Parmanik, 14,066 rupees he had got, and by an HDFC check on 3/4/2023. So he has encashed it, but he is now prepared to return it back. Then Nabaghan Patra, check has not been received. They have not given any check. Kartik Parida, the check has been returned back due to the death of the employee. So, my lords, we have said that the benefit may be given to the legal heirs. And 41 persons have already, the checks are there before that.
But my respectful submission is that, but their simple application is that there is a typing mistake. But instead of 25FF, the order shows 25F. So lordship looks at the order itself.
Yes.
So kindly have a look at those two orders that is
Yes.
trying to referring to. At order dated 16/1/2023.
Yes.
The last paragraph.
Yes.
The court accordingly directs that in respect of the said 56 workmen in the list produced in the court today, the petitioner, IFCO, will comply with the requirements of section 25F of the Act within the period of 12 weeks from today.
Correct.
That has been complied with.
Correct.
So, lordship, kindly have a look at 25F.
Yes.
Sir, 25F says,
yes,
no workman employed in the industry who has been continuous service for not less than 1 year under the employer shall be retrenched by that employer until the workman has been given 1 month's notice in writing, indicating the reason for retrenchment and the period of notice has expired, or the workman has been paid in lieu of such notice wages for the period of the notice. B says the workman has been paid at the time of retrenchment compensation which shall be equivalent to 15 days average pay for every completed year of continuous service or any part thereof in excess of 6 months. And C says notice in the prescribed manner is served on the appropriate government when such authority as may be specified by the appropriate government by notification in the official gazette. So let's kindly have a look at 25FF.
Yes. Yes.
It says where the ownership or management of an undertaking is transferred, whether by agreement or by operation of law, from the employer in relation to that undertaking to a new employer, every workman who has been in continuous service for not less than 1 year in that undertaking immediately before such transfer shall be entitled to notice and compensation in accordance with provision of section 25F. Am I clear, Malad? And as if the workman
So you determined the date of transfer 1 year before the transfer.
Correct.
This employee should have been within that 1 year before the transfer.
Correct.
His employment should not have ceased within that 1 year.
Exactly. That is exactly the difference.
Ah.
But therefore, this is a
So
case.
all of them, they ceased to be employees earlier than 1 year.
Yes.
Much earlier than 1
Much
year.
earlier than. So your lordship has taken note of everything while passing the order itself. So 25 is the appropriate provision that has been made applicable. But there is no ground to recall the order and entire thing to upset the entire rhythm. Your lordship have taken the exercise of hearing all those matters.
Yes, Mr. Palit.
Malad, I'll just draw your lordship's attention to your lordship's order. This 33/2022. It was an interim arrangement that your lordship worked out. Why, Malad? Because of this. The issue was, I'll place this order. Order number 2022. Heard the second paragraph. Heard learned counsel for the parties. Both the writ petitions having arisen from one order, they are heard together and the following common order is passed thereon. The petitioners in both the writ petitions challenge the order dated 18/5/2009 passed by the Industrial Tribunal Bhubaneswar in ID case number 4 of 2005. Reference made in the said case is whether the action of Messrs. Oswal Chemicals and Fertilizers Limited, Musadia Paradip, in refusing employment to Vishwanath Chaudhary and 49 others with effect from 29/7/2004, Sri Ajay Sahai and 46 others with effect from 3/8/2004, and Sri Gurucharan Raut and 53 others with effect from 7/8/2004 is legal and or justified.
Yeah.
If
So
not-
now just stopping
So,
here.
Malad.
When was the when did the new management take over?
1/10/2005.
1/10/2005.
So 1 year prior to 1/10/2005 would be 1/10/2004.
Malad.
So if they had been appointed between these two dates, that is 1/10/2004 and 1/10/2005,
Malad.
and they had been retrenched,
Malad.
then 25FF would apply. So the point being made is, since all of you were retrenched at least 6 years, I mean, at least more.
That issue was covered. That
More
issue
than
was
3-4 months prior that.
no, that issue was covered here in this award. Although altogether 151 workmen challenged the refusal of their employment by Oswal. Messrs. Indian farmers, they're not saying retrench. They said we were there in the roles, we were being born on the roles, we had evidence to produce before these. It was on that issue that it was remanded to the tribunal. So this was a plea taken by the management. Whether the plea was right or wrong or was factually incorrect was thrust out before a fact-finding commission forum, that is the tribunal. Is the petitioner in writ petition number so and so, opposite party in the writ petition, they were directed by the tribunal to reinstate only 8 workmen.
No.
And that too without back wages.
No, Mr. Palit, this reference itself fixes the dates.
Yes.
The reference itself says you were refused employment with effect from 29/7. And Ajay Sahai and 46 others with effect from 3rd/8. And Geeta Guru Charan Raut with effect from 7/8. So the reference itself says you people cease to be in employment from these dates.
Correct.
That's how the reference, and whether that was legal or not was the reference.
No, thereafter your lordship, thereafter your lordship referred it back. Thereafter your lordships referred it back, saying that learned counsel for lordship may kindly bear with me. I'll travel. My lordship may travel with me for the rest of the order. That they were directed by the tribunal to reinstate only 8 workmen, and that too without back wages. So the workmen, through their union, filed writ petition number so and so 2009 for reinstatement of the remaining workmen and for back wages of 8 workmen who were directed to be reinstated. On the other hand, Messrs. IFCO challenges the award on the ground that they are not liable to give employment to any of the aforesaid workmen. Learned counsel appearing for Messrs. IFCO drew the attention of this court to the middle paragraph of paragraph 12, middle of paragraph 12 of the award passed by the tribunal, which reads as follows. The Oswald being no more in existence, and in the meantime it has been taken over by the management of IFCO. The IFCO is directed to reinstate the workmen named above in its organization. Learned counsel appearing for Messrs. IFCO submits that Messrs. IFCO have taken a plea in their written statement before the tribunal that they are not liable for providing employment to the aforesaid workmen in view of the sale agreement executed between them and Oswald, but no issue has been framed in that regard. So he prays to frame an issue in that light and remand the matter back to the industrial tribunal with the direction to direct the issue, decide the issue, and remit back the matter to this court in a stipulated period. Learned counsel appearing for the union has no objection to it. The industrial tribunal ought to have framed an issue in that light of the submission of the learned counsel for the petitioner, as it is essential for the right decision of the case, but it has not been done so. On the following issue, the following issue is framed. Issue whether IFCO is liable to give employment to all the 151 workmen members of the union. ID case number 4 of 2005 is remanded back to the tribunal. Bhubaneswar, your lordship, framed the issue and sent it back. Bhubaneswar with a direction to give its findings and reasons. Therefore, on the above issue, after giving opportunity to both the parties to adduce evidence, additional evidence, and return the record to this court with evidence adduced and its findings within a period of 3 months from the date of receipt of this order, parties are directed to appear before the tribunal on 2/9/2010. Looking at the plight of the workmen, your lordships have passed this order. So paragraph 2, pursuant to the above order, the tribunal again heard the parties and passed another award on 16 December 2010, the operative portion of which reads as under. 9. In view of the discussions made above, it is held that all those disputant workmen whose retrenchment is found to be illegal are deemed to be employees of the undertaking as on 30/9/2005. There is no dispute that all the employees who are on the rolls on 30/9/2005 have been absorbed by the purchaser without interruption in their services. Therefore, those disputant workmen in whose favor reference is answered are deemed to be entitled to be absorbed without interruption in their service. That way, the first condition of clause A of 25 FF of the Act is found satisfied. As regards the other 2 conditions, no discussion is required, inasmuch as neither the first party management has taken any plea that these conditions, so far as the absorbed employees are concerned, were not satisfied. Therefore, the tribunal concludes that all the conditions in the proviso of 25 FF of the Act are satisfied, and transferee has a liability to absorb all the disputant workmen.
No,
retrenchment is found to be illegal.
The disputant workmen are only 8.
Well, it's 100. So therefore, your lordship said,
yes,
the issue concerned, this paragraph assumes, my lord, subliminal importance.
Yes.
The issue concerns the expression disputed workmen without categorically answering the dispute. Framed for the tribunal to address by this court vis-a-vis the IFCO, vis-a-vis whether IFCO is liable to give employment to all the 151 workmen. The tribunal seems to have indirectly restricted the relief to only 8 workmen by describing them as disputed workmen. Mr. Das, learned counsel, appearing for 51 of such workmen, as well as Mr. Singh, appearing for another 51, make a grievance that their clients are ready with additional evidence to be adduced as proof of their employment with Messrs. Oswal before it was taken over by IFCO. Their grievance is that no opportunity was given by the tribunal to them to place the said evidence before it. That is the reason why your lordship passed it, with a view to obviating paragraph 5, my lord. This is where your lordship, my lord, the whole dice turns. With a view to obviating further remand, which will delay the matter, this court considers it appropriate to direct as under. 1. The workmen who wish to be reinstated in service and who have not crossed the age of superannuation, this is the direction, shall present themselves before the General Manager IFCO at Paradip between 18th and 22nd April with all the relevant documents. The General Manager will arrange to have those documents checked and verified. It will be open to the IFCO if the documents are found in order to either offer workmen whose identity is established reinstatement or compensation in lieu of the reinstatement. This is without prejudice to the rights and contentions of both the workmen as well as IFCO. It is expected at least some of the issues that the workmen might have would get settled in that process, written report of such proceedings. So therefore, the challenges to the award was also pending before your lordship. So that award being pending, this was an interim direction which your lordship felt would be proper, looking at the fact that 17 years these hungry men have been agitating their livelihood rights before this the industrial forum and various forums.
Your lordship's order has been complied
Kindly,
with.
sir, kindly allow me to complete my submissions.
Complied with, sir.
Sir, these are hungry men who have been running around, my lords, and that is why looking at their plight, your lordship, normally your lordship will remember, my lords, in these such circumstances, your lordship normally do not pass such a direction as an interim stage, but here that impelled your lordships to pass such a direction is this, that for 17 years these people have been running from pillar to post.
They say natural justice has not been followed. They could not
Pillar
produce the record.
don't lighten the burden by saying that, and now they want to prove, my lords, now the management wants to my lords, pull a fast one, taking advantage of the fact, my lord, they want to 15,000, 17,000 per workman and let them go home. Where will, my lord, in lieu of reinstatement, your lordship directed compensation. Lordship did not spell out 25AF or 25FF or whatever, my lord.
No, because that would depend, because the question was this. You had to show that you were different from those 8 disputant workers.
We had to show that we
or that is similarly placed as 8 disputant.
My lords, grateful, my lords. That is exactly the exercise that should have been undertaken. Let them undertake that exercise. Do they deny that the documents were not in order? No such denial is forthcoming from their side. Have they said that we have checked the documents, we found them to be not in order?
No. So when that order, now you have to read the order dated 16/1.
My lords. 16.
They made a statement, they'll comply with 25F.
My lord.
Which means they were proceeding on the basis that you were not within 25FF because you did not fulfill the condition of 25FF that you should have been in employment as on 13/9/2005. They were not accepting that. So they made a statement saying, we will pay you compensation under 25F. Now, this is that order. So after receiving these checks, now you want a recall of this order.
My lords, why this order was passed? Why this order was passed is because of 25FF. Why? Because, my lords, it was an automatic 25FF postulates an automatic continuance of employment. It never postulates a break in employment, my lords. That's exactly the statutory, the mandate of the statute.
The reference itself recognized that they ceased to be in employment from certain dates.
Right.
No, that was the reference which, my lords, your lordship's order over.
And whether that retrenchment was legal or not was the question, not whether those dates were correct or not.
So therefore, my lords, it went, therefore, to test that retrenchment, it went to the tribunal. So to overcome that position, your lordship has very deliberately passed this order. Those who wish to be reinstated in service, your lordship used the word reinstated. Reinstated has to be, in that sense, has to connote to 25FF. It does not mean 25F.
But
It
we also
would
gave them an
allude
option
to, yes, my
that
lord.
they will offer either reinstatement or
Correct,
compensation.
correct. Grateful, my lords. Grateful, my lords. My lords, we are extremely grateful that your lordship passed this order. The exercise of verification of details. So the exercise of verification of details, have they said that no, they have not been, the documents were not found in order, however we are offering a reinstatement? No. To obviate and to, my lords, they have not said so. There is no such denial forthcoming. So to obviate that, my lords, time-consuming process of again sending this workman back to the labor tribunal, your lordship wanted to find out a shortcut as an interim measure.
Sir, kindly see the prayer.
And this is
Sir,
without
kindly see the
prejudice.
prayer in the
Lordships
petition.
categorically,
Prayer in the petition,
my lords, categorically, your lordships have said, this is without prejudice to the rights and contentions of both the workmen and the IPCO. It is expected that at least some of the issues that the workmen might have might get settled in the process. Your lordship never meant to throw these people to the mercy of
Not
at
from
the mercy.
mercy. The order was passed in your presence on 16 January.
My lords,
Where's
my
the
lords.
question? The order of 16 January was passed in your presence.
My lords.
And the application not
My lords,
recalled.
what was, my lords, if the statute gives me a better right, do I not have a better right, my lords, basing on the documents? Now, my lords, I am shut out. I am now, that was the reason, my lords, why we strongly protested and submitted before your lordship. And your lordship was kind enough to ask us to, my lords, gracious enough to ask us to, my lords, come with the checks, and we have come with the checks. We now want to stake our claim and have, my lords, we want to prove that we had the documents. To, my lords, if we have a claim under 25FF, we may be at least given an opportunity. So what do we do, my lords? Where do we go from here? What happens is, my lords, they are now trying to, my lords, trying to close the gate. Sluice gate is going to be closed. On our rights. And can your lordship imagine, in this day and age, 15,000 for 17 years of litigation, they are poor people. Some of them have died. 15,000 for 17 years at this age and this stage. At this day and age, 15,000 to 17,000. And they have no defense against that. They are throwing us to the 15,000.
Now I can hear them.
My lord, both the seniors are telling I should get some smoke.
All right, you also say, sir.
My lord, in the second, this WPC 9842 by 2009, I am for the opposite party 2, my lord.
All right.
The union has not supported the interveners nor the senior council they have engaged. Only we are protecting the workers, and after your lordship passed this order, basing upon their report, my lord, 30th March 22, your lordship passed the order for verification, and 16th January they submitted the report. The copy not served and took the order, my lord. My lord, last occasion your lordship directed to return the checks we also returned 11 checks, my lord. Out of 8 workmen, 6 workers are here, and we have filed the memo.
Now, my lord,
So if your lordship looks at, your lordship looks at the entire order.
Leave it to your lordship, my lord, whether we will be getting a chance to.
Any of the dates.
We will get a chance to, my lord, work out our rights. They are all returning the checks, my lord.
On 30th March itself,
Now the entire picture is before your lordship. Everybody is returning the checks.
My lord, 30th March also I told they are trying to break the union, man.
All right, sir.
They are trying to.
We'll go for a full. All right, sir. We will go for a full-fledged hearing. All right. So this IA number, which is your IA number, sir?
My lord, 6905 in 9842.
That's your IA?
Yes, my lord.
What is your IA then?
That is 4647 is their IA.
4647, only 25FF to be corrected.
4647.
I know, but that can't be corrected like that. 4647 and 6905/2023. Both these applications seek either a recall or modification of the order dated 16 January 2023, passed by this court, which recorded the statement of Mr. S.P. Mishra and a senior counsel appearing for the management that compensation would be paid to the workers in terms of Section 25 capital F of the Industrial Disputes Act 1947. the contention now raised on behalf of the workmen is that the compensation ought to have been under section 25 double F of the Act and not section 25 capital F of the Act. Full stop. Paragraph. It is claimed that the workmen were in service of the employer as on 30th September 2005, the date on which the present management, that is IFCO, took over, and therefore section 25 double F of the Act would apply. Paragraph. Since this was the bone of contention between the parties prior to the hearing on 16 January 2023, this court had, in its order dated
30th March. 30th March.
30th March
2022.
Put in place a mechanism to obviate the delay in their getting relief, and for IFCO to undertake an exercise of verification of the claims of the workmen. Paragraph. It is upon the conclusion of this exercise that the order dated 16 January 2023 came to be passed. Paragraph. On the previous date of hearing of these applications, that is 12th May 2023, the court was informed that although checks had been distributed to each of the workmen by IFCO in compliance with the order dated 16 January 2023, those checks had not been encashed by the workmen, and that they would be prepared to return the checks, unencashed checks, to Messrs. IFCO. Paragraph. The applicants in IA number 4647 of 2023 have filed an affidavit. This Sushanta Kumar is yours. Filed an affidavit and enclosing a list of workmen who are returning the checks to the unencashed checks to the management. Full stop. While there are 44 checks, there's an explanation offered in respect of the remaining 9 workmen, is it?
Except 1. 8.
8 workmen. Why their checks could not be a bracket except 1 whose checks were not encashed. Full stop. Even in respect of one of them, that is Jyotish Narani Mohanty. Correct? So who is the one who is prepared to return? Who's
Berunadhar Parmanik, 42 serial.
42. Berunadhar Parmanik.
In respect of one of them, Sri Berunadhar Parmanik, it is stated that he is prepared to return the money that has been encashed within a period of 2 weeks from today. Paragraph. As regards the applicants in IA number 4647 of 2023, a separate memo has been filed. Again, tendering
6905. Our IA is 6905.
Yeah, 6905. A separate memo has been filed, returning 11 checks.
11 checks. They are the.
How many of them are there? 11.
11, my lord. Out of 8 workmen, those originally granted reinstatement, they are 6 here. 6 jana plus 5, 11.
All right.
Original, I have handed over to Mr. Sadani.
In view of the above developments and without expressing any view on the merits of the claims of the workmen,
original letter
and leaving it to both the management IFCO as well as the workmen to urge all their pleas upon restoration of the writ petition, this court recalls the order dated 16 January 2023 and restores writ petition civil 9842 of 2009 to the file. Full stop. And then in writ petition civil 9842 of 2009, list before the
30th March order will remain, sir. 30th March order.
because they've not asked for a recall of that. So that is only an interim arrangement. They can still argue whatever they want. That exercise is complete. It's worked itself out. Sir. The 30th March has worked itself out.
Crystallize the point then, whether 25F will be applicable or FF will be applicable.
All right. You say the point on which the present writ petition is set down for arguments is whether, in respect of the workmen who are parties in the present writ petition, the provisions of section 25F or the section 25FF of the Act of the Industrial Disputes Act 1947 would apply. Question mark. Paragraph list.
My lord, my 11 original letters and checks submitted to management.
Yes, I've already noted that, sir.
I know, my lord.
You want us to read out the whole order?
No,
to you,
no,
sir?
man. Sorry.
You should trust me when I say I have dictated. All right.
Oblige.
List for hearing on 23rd August. All right.
Let the checks be kept on record.
No, you take it back, sir. The original checks have been handed over
We are handing
to
it
Mr. Sarangi, appearing for IFCO. The memos are retained on record. All right. All right. That 11 checks also. That's been.
Item 3, my lord. This same 16, our writ petition 16443 to be restored.
All right, just put all three IAs right on top and say all these.
And IA is 6987, my lord. Item 3.
All right.
So
And
recall
then
the
say
order.
both these writ petitions are restored to file. Right.
Grateful.
Right. All right. Right. Sir.
My lord, that is very difficult. Your lordship.
Yes.
This
admission item number one.
is a matter relating to restoration of the writ application dismissed for default, madam.
Right.
On 14/9/2022.
All right. All right. For the reason stated therein, the order is recalled and this writ petition is restored to file. The main writ petition say list before the roster bench.
May I press status quo, my lord? Interim order was there. May I press status quo?
Yeah. Oh, yeah. All right. List on 29th August, interim order to continue. All right. Right.
All right.
Right, sir.